Okay, we're back. Let's do the third part of our lecture on Lesson 6, Passing a Law. So sometimes bills are school class bills. These are on a lighter note. They're dropped at the request of a school class or maybe an individual student. And these are usually requests that are innocuous. They want to name a state dinosaur or something. Very hard to turn down, these kids. We recently had a high school student who had us name lemonade the official drink of Arizona. Don't tell Arnold Palmer, because most people thought the official drink of Arizona was the Arnold Palmer, which was the golfer's favorite drink, which was half lemonade and half iced tea. So, but now the official drink is lemonade. Don't tell Arnold. All right, let's go over the process of passing a law in Arizona. It is similar in other states, but not identical. There are 21 steps in the process, up to 21 steps in the process, and it can involve deal-making, compromise, backroom meetings, quid pro quo. It is often said that lawmaking is like making sausage, something that people probably would not like to see with their own eyes. So what are the steps? All right, drafting the bill, introducing it, first reading, assignment to committee or committees, hearing in the subject matter committees or committees, rules committee hearing, having a second reading, having the caucus review it, going before the committee of the whole and getting voted out with or without amendments, a third reading of the bill, and then, if it passes, it's transmitted to the other chamber where steps 3 through 9 are repeated. And then, if no changes were made in the second chamber, a final reading is made in that chamber. In other words, if when it went through the committee there, they didn't amend it, and it passed out, and it goes to a full floor vote in the second chamber unchanged, this is called a final reading. If, however, the second chamber passed the bill and they put an amendment on it, so it's now different than it was in the first chamber that sent it. If the bill's sponsor agrees with the amended version, the second chamber passes it over, and then it is final read by the originating chamber with the amendment on it, because the originating chamber has to vote again to approve it in this new changed form. But if the bill's sponsor in the first chamber rejects the amendments in the second chamber, then you have two different versions of the bill. The one that was passed out of the first chamber and the one of the second chamber with an amendment to the bill. You can't have two versions. So at this point, the bill will go to a conference committee. And these are a small number of members from both chambers who meet and try to arrive at a compromise version. And if they do, that compromise version goes right back to both chambers, and it is final read in both chambers. And then it is transmitted to the governor. So again, bill goes through the first chamber, goes to the second chamber, passes out of the second chamber in identical form as the first, right? That bill then goes up to the governor for signing or veto. If, on the other hand, the bill goes out of the first chamber and the second chamber amends it, two different versions, they have to be reconciled. Both chambers send a small group of legislators to meet together in a conference committee. If they can work out a compromise, the compromise version goes back to both chambers. They vote on it. If they both pass it, it goes to the governor. If they can't agree on a compromise, then the bill is usually dead, although some states have other ways to try to get a reconciliation. All right, so the bill wound up being transmitted to the governor. The governor can allow the bill to become law by taking no action, or the governor can make it law by signing the bill into law. If the governor vetoes the bill, in other words, the governor doesn't like it, so the governor vetoes it, it can only become law in almost all states when a supermajority of the members, usually 2/3, possibly 3/5 in both chambers, vote to override the veto. In some states, but not Arizona, the governor can return a bill to the legislature with proposed amendments, which, if the legislature adopts, gets the bill signed into law. And by the way, legislative ballot referrals, memorials, and resolutions do not go to the governor. A ballot referral is when both chambers pass a law in identical form that will go on the next statewide ballot for the voters to approve or reject. That doesn't go to the governor. Memorials and resolutions are benign statements the legislature makes, honoring people, declaring certain days, National Hot Dog Day, or, sending a message to Congress that we want you to do something. It's just the will of the chamber or the legislature, so the governor doesn't get to veto it or approve it because it doesn't involve the governor. All right, let's talk about drafting a bill. Right, we're talking about the process of how a bill becomes law. So at some point, the legislator is going to go to the legislative councils and say, write this into law. And it might simply involve the bill drafters amending model legislation or legislation from another state or legislation that some interest group gave the legislature, or it might involve a legislature sitting down with the legislative council and explaining what he or she wants, and then legislative council puts it into legal form. So in Arizona, that process begins when a legislator or as a designee requests that the office of a legislative council, the bill drafters, open up a bill folder. A bill folder is a term for the file that bill drafters maintain for each bill, and it contains the paperwork for it. That results in a bill drafter, a legislative attorney specializing in the topic area of the bill being drafted, beginning to work on the bill with input from the sponsor or somebody who the sponsor designates to represent him or her. The sponsor decides the bill's content and language along with what amendments will be allowed. Equally important, sponsors can usually keep unwanted amendments, called hostile amendments, off the bill. See, sometimes the bill will go through the amendments are written after the bill is introduced, but the bill is drafted and it starts going through the system. Sometimes a bill has to be amended, and either leg counsel or sometimes the committee that the bill is being heard in, their staff will write an amendment. But sometimes other legislators, especially with their committee members or during the committee of the whole, can offer amendments that they want to the bill, which are hostile, which are not what the sponsor of the bill believes in and wants. Or there could be an amendment designed, if it's added on, to lose votes and make the bill fail. These are hostile amendments, and generally the majority party will ensure that hostile amendments do not get onto majority party bills. A poison pill amendment contains a provision that makes the bill less attractive to members, usually enough members to kill the bill, or it's poisonous to the governor who will veto it. Sometimes somebody will propose a poison pill amendment to a bill sponsor, and the bill sponsor doesn't realize it's a poison pill and lets it get on, and then the bill winds up dying for lack of votes because the poison pill lost votes, or it gets vetoed because the governor does not like the poison pill provision. Co-sponsors are legislators who support a bill and, with the sponsor's consent, formally sign on as co-sponsors. Legislators co-sponsor bills to show support and share some of the credit. Co-sponsoring bills also allows legislators to portray themselves as prolific bill sponsors, even though all it takes to co-sponsor a bill is to sign your name on the intro set sheet, which has everybody's name. All the legislators' names are on the front page of the intro set, and you initial next to your name and you're a co-sponsor. Each state legislature has its own bill drafting rules, which its bill drafting attorneys know best. Legislators call the legislative bill drafters, tell them what they want the bill to do, and then review the final draft sent to them. That's drafting. Now, perhaps the process of drafting can best be explained in the language of the bill drafters themselves. And this is from the 2003 Arizona Bill Drafting Manual, which they wrote. They say, the drafting process begins with legislative counsel, drafter, obtaining the facts, policy, and objectives for a legislative proposal from either the legislator sponsoring the bill or the legislator's authorized agent. The drafter then converts the sponsor's request into proper form, style, and legal terminology and fits the proposal into the framework of existing statutory law. The drafter strives to produce a draft that is coherent, concise, understandable, and free from ambiguity. The drafter considers pertinent provisions of the Arizona Constitution, court decisions, and Arizona revised statutes, the Internal Revenue Manual, the annual report on defects in the Arizona revised statutes and state constitution, and other relevant sources. The drafter adjusts minor problems or conflicts and discusses more significant issues with the sponsor, including suggesting alternative approaches. So I should say they do more than form and style. They also make sure that it doesn't contradict with other sections of law. They also make sure that it's understandable and coherent. And they also fit it into the proper place that it belongs in statute. Legislative bill drafters usually return the finalized bill to the sponsor with other necessary documents attached, again, like the cover sheet with all the names. In Arizona, our legislative council attaches to each bill a cover sheet with a list of names of every House and Senate member so the sponsor can go around and ask if they want to sign on as co-sponsors. In Arizona, the combined bill and member cover sheet is called an intro set because both are needed to formally introduce bills. I rarely go around looking for co-sponsors. It really doesn't make any difference. Co-sponsors like it, but it doesn't really help the bill. I've even had bills where co-sponsors have voted against the bill in the end. So much for co-sponsors. All right. Most legislatures, by rule, have windows of time dictating when members can request legislative bill drafters to draft legislation and when the chief clerk or Senate secretary can accept bills for introduction. The bill drafting window can begin months before the start of a session and extend a month or so into the session, although Legislative Council bill drafters draft amendments throughout the session. The window to introduce bills is narrower. Remember, the drafting window starts months before, but when you can introduce bills is a much smaller, compact period. It usually extends a few weeks before the session starts to maybe a month after it begins. And these constraints are more relaxed for legislatures that meet year-round. The window to introduce, after the bill sponsor examines the intro set and perhaps gets co-sponsors to sign on to the bill, the intro set is ready to be introduced by presenting it to the Senate Secretary or the Chief Clerk of the House. And the bill's journey from their hands to passage is discussed in the next lesson. So that's the end of Lesson 6.